Professor Triggs, Your Honours, distinguished guests, ladies and gentlemen, there is a certain rightness about this venue for the gathering of the Australian Law Teachers Association here in the understated modernity of the Harbourside Room at the Museum of Contemporary Art. The museum, of course, exists because of the benefaction of John Power, a graduate of Sydney University, who left an extremely substantial bequest to the university. Although he trained in medicine, he was by instinct and largely by lifestyle an artist and a collector. He spent much of his time abroad, and he had a view that it would be a good thing for the Australian public if we could be kept abreast of ideas and theories in contemporary art. And so it was his wish in the bequest that he made that his trustees acquire and house works of contemporary art that would keep us all in touch with international trends. Well, you can understand the sort of gorgeous synchronicity that we are all here tonight with a conference themed on the idea that law teachers are preparing the next generation of lawyers to take their place in the contemporary international legal environment. In an odd way, that makes it a little bit surprising, despite the warmth of Claire's introduction, that I was invited to be your speaker tonight. I say that because the thing that I've always liked about the MCA is not the internationalism of the Power collection, but the fact that it was housed in the Maritime Services Building for a long time in the Maritime Services Building, while that building was a pristine and beautiful example of Art Deco architecture, before the arrival of what is, Craig, if I can explain it to you, correctly named the Mordaunt Wing. The Mordaunt Wing has been described by one critic as a Mondrian box 10 years after it was fashionable elsewhere. I think I would always incline more to the gracious Art Deco than to the boxy modern in architecture, but I particularly like the old Maritime Services Building, standing as it should by itself, because it's always reminded me of a sort of monumental stone version of the Commonwealth Bank money box. For people of my age, that references very deeply held ideas of a solid, insular, suburban security. And these are ideas that at something close to a subliminal level are very appealing to the sort of person who ends up being a judge. I explain that because it's necessary background to understanding why I think I have been invited to speak tonight, and why I note that Justice Slattery and the President of the Court of Appeal have given presentations at your conference earlier today. Although I haven't actually raised it with her, I think in her own way Professor Triggs is extending an olive branch to us. This is in consequence of some rather hurtful remarks that were made and widely reported earlier this year. In the context of a discussion of the planned national regulation of the profession, Professor Triggs voiced the concern that the national standard might reflect outdated and parochial views on legal education, a concern stemming from the well-known tendency of admission boards to be made up of judges and retired judges, of whom it was suggested they are inclined to think that legal teaching should replicate the teaching that they enjoyed 40 years ago. Well, I mean, where do you begin with an attack like that? If it wasn't for the happenstance that Professor Triggs invited Justice Slattery and Justice Alsop and myself to contribute to this gathering of legal academics, convention would have prevented us defending ourselves in the public sphere. And of course, apart from anything else, it's simply wrong. I was at Sydney University over 40 years ago, at a time when it was requisite, in order to obtain a law degree, that one undertook a separate entire year's study in conveyancing, not as an adjunct to real property, but as a subject worthy in its own right. Now, as I understand it, that is no longer a requirement for a degree at Sydney University. And I am entirely relaxed about that. At a more fundamental level, this was an attack that wasn't worthy of an academic because it flies in the face of history. When the New South Wales Admission Board was in its infancy, the uncomfortable truth is that Sydney University was not interested in teaching law. The prevailing view, heavily influenced by John Woolley, the first professor of classics at Sydney University, was that the university was no place at which to acquire legal skills. Woolley famously observed, "The soundest lawyers come forth from schools in which law is never taught. The most accomplished physicians are nurtured where medicine is but a name." Is it any wonder that against that background, when the Legislative Assembly established a select committee to inquire into what might be the best method of qualifying young members of the colony to enter the legal profession, Sir Alfred Stephen, then Chief Justice of New South Wales, said the power should be handed over to the judges as one naturally incident in them. As far as the allegation of parochialism goes, the curriculum set by the first admissions board included studies in Cicero, Virgil, Euclid, and algebra. Although Sydney University is the oldest university in Australia, as would be well known to this audience, Melbourne and Adelaide had established and thriving faculties of law well before Sydney. It is true that Sydney undertook some teaching of law as part of a general degree in the mid-19th century. The lectures were given by John Hargrave, then Solicitor General, later, I'm pleased to say, a judge of the Supreme Court. The unedifying history of that period of legal education has been fully detailed by Linda Martin in her splendid article on the social history of legal education in 19th century New South Wales. The fact of the matter is that while attendance of students at law at the classes set by the admission board were burgeoning, Hargraves ended up with 5 or 6 students. This was despite him making his lectures, as he was to tell members of another select committee, as popular as lectures on jurisprudence were likely to be without making them unworthy of a university. Part of the difficulty may have been that Hargrave did not consider the study of law suited to the education of a gentleman. As Martin explains, he made a point in those few lectures that he delivered at Sydney of omitting those sections of Blackstone's commentaries which he described as containing mere professional details. He subscribed to the view that if it was to be a professional education, then it must be provided by the profession itself. He favoured the idea that we should establish Inns of Court here in New South Wales. Something fairly similar was embraced by Thomas Fisher, that other great benefactor of Sydney University, although he proposed that it be styled the Lyceum of Justice. It was to comprise both barristers and attorneys. They would select from amongst themselves benches who would regulate admissions and organise the giving of lectures and the conduct of examinations. And one would have to ask, what better model could there be for the teaching of law than the Inns of Court? Beautifully portrayed in one of his introductions to the yearbook, or one of the yearbooks by Maitland, as in their heyday, consisting of gregarious, clubbable men, grouping themselves together in hospices which become schools of law, arguing, learning and teaching, the great mediators of life and logic, a reasonable element in the English nation. And more than this, of course, right from the early days of the reign of Elizabeth through to the Revolution, one had that splendid egalitarian tradition at the inns of the benchers and the students of law attending every Saturday night between All Hallows Eve at the end of October through to Candlemas at the beginning of February to dance together, dancing the pavan and the other 7 old measures. It is possible, although not, I think, at Sanity Records, to obtain a CD entitled The Dances of the Inns of Court. And can I tell you this? If you settle down with that CD playing, a glass of Madeira, and a copy of the less sensational parts of Thorne's translation of Bracton, you have an understanding of the culturally vibrant, intellectually rich manner in which the law was taught when it was the province of the judges. At the end of the 19th century, a grudging Senate at Sydney University, under the chancellorship of William Manning of the Supreme Court of New South Wales, member of the Admission Board of New South Wales, finally set up a faculty of law. All of it at Manning's insistence. He considered that the spirit of the age demanded a greater emphasis on technical instruction. It was not a view that commended itself to everyone. Indeed, it was not a view that commended itself to George Knox, who was the first teacher in law. Knox considered that Manning had embraced the vulgar test of utility in education. It's a sort of an old debate, and it's kept going on. In the year of my birth, 1951, at the 7th Law Convention of Legal Education in Australia, the ALJ, in an editorial piece speaking of the convention, observed, "The profession's assumption that the business of law faculties is to train practitioners results in legal education being dominated by practical rather than intellectual interests." The debate has tended to be, as I understood it, between the academy, concerned to foster critical thinking and the sort of benefits of a liberal education, and the essentially technocratic demands of professional bodies and the admission boards. That's where I assumed matters rested until, because I have an interest in medieval history, I found myself reading one of Professor Thornton's articles because it was titled Gothic Horror in the Legal Academy. And that was my introduction to the new knowledge economy and to neoliberalism as it applies in legal education. I have I think it's fair to say, an imperfect grasp of economic theory, but if I've got the gist of neoliberalism, then I rather sense it's all around us. We are, as I think I've already noted, eating tonight in an art gallery. 40 years ago, that wouldn't have happened. That's because 40 years ago, it was enough for public art galleries to display art to the public. Now it's necessary for art galleries to release the underlying economic value of the asset. I'm not entirely sure that I've got the verb right, but I think the MCA is monetising us. Or it's possible that we are monetising it, but you understand where I'm coming from. In any event, I've found in reading a number of Professor Thornton's articles a certain level of comfort. That is because, as I see it, the judges are not the target of Professor Thornton's analysis. It's that Professor Hilmer and all who have followed in his train have taken the fire from us. She is concerned to point out the risks that the market economy will skew teaching in law. And it was through Professor Thornton that I became familiar with what I understand is the economically attractive idea of the block teaching of law, involving, so she explains, teaching an entire subject full-time in 1 or 2 weeks, or possibly even 1 or 2 weekends. I understand that she did a major survey, I'm sure you're all familiar with this, in 2007. And the result of that survey revealed that students like block teaching. That could be 3 months. To return to students' taste for block teaching. When I studied law under Professor Woodman, doing real property, we devoted an entire term, and in those days there were terms, and there were 3 of them. The entire middle term, which as I recollect it was the longest term, 10, 11, possibly even 13 weeks, were allocated entirely to the rule against perpetuities. It required a close study of those class-closing rules, of coming to an informed understanding of why, over the years, odd as it might seem by 1972, there were good reasons why the law had an irrebuttable presumption of the fertility of female octogenarians. Why it was significant that the last life in being of the testator who wrote the will under the reign of George IV survived with such interest for law students. Under Professor Woodman, we didn't learn these things because anyone seriously entertained the view that we were likely to run into perpetuities problems. By 1972, they weren't the stuff of everyday practice. We studied the rule against perpetuities because, inspired by Professor Woodman, in those artificially lit, subterranean, utterly soulless lecture theatres of the Phillip Street Law School, we sensed something of the inspiration of the common law. When Sir Frederick Pollock crossed the Atlantic in the summer of 1895 to deliver a commemoration address to the Harvard Law School Association, he was delighted to find how the common law was prospering in what was then a far-flung and remote part of the world. He came back to write how within the first quarter hour of his exchange with the Harvard Royal Professor of Law, they had been deep in discussion about the question of whether determinable estates in fee simple are known to the common law. And if they are, what are the properties of those estates? Now, if I've picked up the drift, there are those of you here tonight who would countenance people emerging from universities across Australia with law degrees, entering legal practice, almost entirely oblivious to the fact that determinable fees simple are controversial. I suppose it had to happen. Last Friday's legal affairs pages of either the AFR or the Australian carried an advertisement by, if I can give the firm its correct name, the Minter Ellison Group, announcing in the usual way the appointment of new partners and senior associates, not only in the Australian and New Zealand and UK and Chinese offices, but the appointment of the new senior associates in the Ulaanbaatar offices. Now, the notion of a fee simple of any character is not a juridical concept in the law of Mongolia as I understand it. The law of Mongolia has until relatively recently been simple on the matter of land holding. The state owned the land. Now, with the assistance of the World Bank and some international aid organisations, Mongolia is undergoing reform of its system of land tenure. It is developing legislation as we speak for the privatisation of land uses. This, coincidentally, as it turns out, coincides with major mineral discoveries in Mongolia. There is, one senses, no doubt, work for an Australian-trained lawyer with a proper background in transnational infrastructure transactions, even if they happen to be a bit light on common law notions of property. Now, I should at this point make clear I do not share the concern that neoliberalism will produce a generation of lawyers lacking idealism or an interest in social justice, and Claire has made very clear why that is right. Certainly in my own experience of the very talented graduates who come to the court, they have every bit as much idealism as those of us who emerged from law schools having undergone our training in the late 60s or early 70s. The focus, of course, of that idealism has changed somewhat, consistently again with the theme of this conference. There is a much greater interest, as I perceive it, on matters international. Fairly tightly focused, I have to say. I was pleased to hear of some of the things that Claire mentioned, since in my own experience, I haven't encountered a law graduate in recent years who isn't entirely focused on the idea of travelling overseas in order to prosecute war criminals, preferably before the International Criminal Tribunal for Rwanda. May I encourage you, in preparing graduates, as you are, for the international legal environment, to encourage them to lighten up a little. Unlike the days when I got into law school, those who now attend our law schools are the brightest of our school leavers. I've got absolutely no doubt that they're all capable of absorbing in a block session what it took Professor Woodman quite a time to convey to me. I've got no doubt that the core subjects, whatever they may be, making up a law degree, will be sufficient to equip them all to handle themselves very capably within the profession. So can I express this hope that in the neoliberal age of the academy, those of you who have made the academy your chosen careers don't find it all too oppressive at times. The contribution to the law and its development made by academics is something that you would all be conscious of, not only in the authoritative texts, but of course throughout the law reports. I have endeavoured to encourage some of the most able of the graduates who have worked with me to consider an academic life, and I'm pleased to say some of them have. And I've done it because it seems to me it's an opportunity for people to make a real contribution to the development of the law if they have the talent. So I trust that the work of the conference goes well, that you enjoy your deliberations. I've been under the enormous strain this evening of being described as a keynote speaker between the main course and dessert. It is not a comfortable brief, and I won't detain you longer. Thank you.